Good morning. Thank you for being here. I'm Beverly Martin, and I'm the director of the Center on Civil Justice. We appreciate you being here today. Those of you who don't know, the Center on Civil Justice here at NYU Law School is devoted to helping the civil justice system be more accessible to the people that use it. And part of that process is studying what's going on in the world of civil litigation. So today we're here to talk about emerging trends in third-party funding. I'm not going to spend any time today making introductions because we're pressed for time and we've got a lot of interesting people with a lot to say. I do need to make a continuing legal education announcement. If you want CLE, you need to sign in and you need to be sure and sign out. If you don't sign out, you're not eligible for CLE. With that, I'm going to turn it over to a great friend of the centers, and that's Professor Tony Seeback.
Thank you very much. Good morning. I'm going to introduce our panelists. I'm going to make a brief introduction to structure the panel's discussion, and then we're going to have a kind of set of questions presented to everybody, and there's going to be a general conversation among the five of us. So our panel consists of, I'm going to go in alphabetical order, Susan Algenhofer, who's a full professor of law at the University of Innsbruck, also a fellow here at the Civil Justice Center and a senior scholar at Yale Law School. Daiwei Chin Feeman, who is the Director of Commercial Litigation Strategies and Corporate Counsel at Parabellum. Maria Glover, Professor of Law at Georgetown University Law Center, and Verity Jackson Grant, who's at the law firm of Simmons & Simmons in the United Kingdom. Now, I'm the moderator, but I'm going to be pedantic. I'm going to give a quick slice of, I think, what the issues are in disclosure, and sort of like, because I teach classes and want to catch the attention of my students in the morning at the 9 o'clock classes that I teach. I'm going to say there are four W's. There are four W's of disclosure. Who, right? Who is supposed to disclose? What are they supposed to disclose? When are they going to disclose if they do disclose? And finally, why? Why to disclose? Now, in the who, you can slice this a little bit finer. Should it be, for example, I'm sure you can come up with more slices, but here are my three: to the adverse party, to the tribunal, and in the United States specifically, although it's highly unlikely, if it's a jury, to the fact finder. Now, on the what, again, these are slices that you can slice finer: the bare fact of funding, the identity of the funder, the amount of the funding, the nature of the funding, and then the contents of the funding agreement, any covenants or any agreements or any promises made in the execution of that agreement. When to disclose? Well, typically here it'd be obvious it's going to be at the beginning of the proceeding, but actually in class actions, there could be a question of it doesn't really matter, or you don't want to have disclosure until the very end, if there's an end, where there's a fee petition. And then finally, why is disclosure merited? Now, that one I actually can't slice, because for me, I just can't imagine why. Now, I mean, there are all sorts of reasons why, but there are many, many different kinds of reasons. And that I'll just leave to our panelists as the sort of, engine behind this conversation. So I'm going to start, and then we'll have time for questions at the end of the hour, I think. I'm going to start with Daiwei, which is, we talked about youth. You're kind of concerned about a question that's not, you think, raised enough, which is how do we define litigation finance or litigation funding, right?
Yeah. What do we call it? Is it legal finance now? Which sounds too close to illegal finance for me. But yeah, what is funding? Why are we disclosing it? I think the question of the intent drives the definition, because we're talking about something that should be disclosed. We can't think of fathomable reasons why. I will say I agreed to this panel because Tony told me there would be someone from the chamber here. But there is not. In any event,
We tried.
oh, we tried. Okay.
Yeah, no, we tried. I said I promised you that we'll try to get something from the chamber.
Okay,
Yeah.
so it's not false pretenses. But so what is litigation funding? What are we getting at? So there's a number of kind of policy rationales that have been floated out there. Some seem more legitimate than others. Tony has views, I think, on that legitimizes perhaps conflict of interest and real party and interest for judges, especially on the conflict side. And then there's things like champerty, fee splitting, terrorism. The latest one is
So what's the range of things that you think could be in the category of the thing call third-party funding. I just.
Yeah,
But like, for
sure.
example, if you look at the orders from these district courts, they use a phrase, right?
Uh,
7.1 orders.
Yeah, sure. So the range is classic single case client directed funding seems pretty obvious. But then we get into situations, are we talking about lawyer directed funding, law firm portfolios, law firm single case? If you look at DNJ 711, there's some ambiguity about whether law firm funding must be disclosed. Then there's kind of the use of funds. Do we care about the payment of legal fees and expenses? Do we care about monetization, hedges? Why would we care about one thing rather than another? Maybe because payment of legal fees implies some sort of control. Maybe it doesn't. Maybe money's fungible. I don't know. Do we care about debt or just non-recourse? What about partial recourse? What about all the other ways non-parties could have exposure to a litigation that could drive these concerns? Could you buy underlying certificates and sue on them? Could you buy a stock that's adjacent that's driven by the litigation outcome? If there's a funder and there's disclosure, how far up the chain do we go? Is it just the funder? Is it the funder? Is it the manager of a fund? Is it the investors behind the fund? What if it's single investor, multiple? Do we care if there may be a sovereign investor? What if there's a secondary transaction? What if there's a tertiary transaction? Who even has knowledge of these things that could be disclosed to the court? But the end point is this all too unwieldy that we can't arrive at a definition that's either too narrow or too broad that would serve these policy goals? And there's obviously costs of this. And I think we've seen that in District of New Jersey. Andrew Cohen from Burford, I think, is probably the foremost expert on what's been happening in New Jersey and the volume of filings and what they've revealed. And not only do we have a misunderstanding of the rule, which has resulted in probably millions of dollars cost to litigants for negative disclosures, but we also have a data set here now that no one's really made an attempt to study except some people in the room, especially Andrew and his team. And I think it's a reason because we kind of know what it shows. But that's like a cost right there of overbreadth, even with an ambiguous definition, that's creating issues.
Okay, is in your opinion, so that you think that people are erring on the side of caution to the point of wastefulness in terms of disclosure? Or do you think that the definition of what counts as third-party funding should be broadened so that what people are now disclosing is properly included?
I think that the people who are proposing the rules should make more of an effort to understand how things are actually done. And I think that's the real problem. And you have this all over the country with various disclosure mechanisms that are proposed. You have some efforts that we've talked about on prior panels to like carve out commercial from certain consumer bills. You do that through like, a monetary threshold for a safe harbor, or you can do it through things like in Florida, they try and carve out, commercial tort claims. But no one even knows really what those are. So people who are doing this don't know how to do it, and that's a problem. And I think the funders in the room all acknowledge we're not partially to blame for the problem, but there's an issue of information asymmetry in terms of how our industry actually operates and what the agreements look like. But we've got a problem here, a bit of a paradox, because the people who want the disclosure want it for strategic advantage, and we can't really give it unless we have an assurance that it won't be used against us.
So from your perspective as a lawyer, as someone who's trained and has a judgment about how the law operates, would you say that it's much easier to answer the question, what is a liability insurance policy, to the question of whether I should disclose it or not, versus answering the question, is there third-party funding? Should I disclose it?
Depends on how it's structured, and then it depends on how far you pull on that string. Because if you were to say, yes, we now do want to disclose, for instance, law firm portfolio arrangements, are we also disclosing contingency arrangements where there's a lot of case law which says that you can't? Are we looking behind the contingency arrangements and behind there, and why? And no one's really articulated a reason. I don't think there's ever going to be an agreement on the definition, because we'll never agree on the intent. At least the people who are fighting about it won't agree, because obviously the reasons used to justify the disclosure are not the same as what is ultimately being sought and why it's being sought.
Okay, so Susanna, we're going to jump now over to your perspective. And I think what we were talking about is whether or not this tempest in a teapot is just an American teapot, or is there anything like this kind of argument or discussion happening in Europe, where there's a lot of what we call third-party funding, however we call it? But are you talking about disclosure at all?
I have to admit, I would need coffee.
You have to speak a little closer, I think.
Sorry.
I guess so, yeah.
Okay. So maybe I would need some strong coffee to digest everything we just heard about the definition and what is cooking in the American teapot. Because I think in Europe, or for Europe, we would have to change the topic of today's conference because it's about emerging third party, not so much about all the different versions of third party. So I think it's more like either consumer organizations or plaintiff law firms using third party funders. And there's a lot of discussion whether or not third party at all should be permissible, but it's not so much about disclosure of details of the third party agreement. And also it's hard for me to speak about European rules because every member state has different rules. But what I can talk about is the new Representative Actions Directive, which for the first time requires member states to introduce kind of consumer class actions, kind of because no law firm, no consumer group can bring an action, but qualified entities. So what are qualified entities? Qualified entities are mostly consumer organizations which have to disclose to become a qualified entity, whether or not they're using third-party funding. And then coming already to the when. So they have to disclose at the beginning to become a third-party to become a qualified entity, whether or not they use third-party funding, but later on also the court or administrative authority, depending on the member state, can ask, are you using a specific third-party funder? Why? Because under the directive, it must be clear that the qualified entity is not unduly influenced by a competitor or another third party. So it's there are rules for disclosure under the directive, but not very specific, like they don't have to tell the defendant about the agreement.
So could you just remind me, who are you disclosing to?
To the court. If
To the court.
asks
Okay.
you, and before to become qualified, you have to report your financial status to whoever is in charge in your member state to tell you whether or not you are a qualified entity.
And is there any public law entity, any public law mechanism to regulate or to certify who can be a third party funder, who's not the court, but who can sort of collect data and to set standards, maybe the reserves, or even require a certain degree of structure in the organization so that there's a responsible party who can be sued or can be subpoenaed?
Not on a European level. Maybe if the FOSS report, with which I think a lot of people here in the room are familiar, comes through, there will be more disclosure at the beginning, but right now there's no public entity dealing with certification of a third-party funding.
And in terms of the reasons to have a debate, I mean, in the United States, we didn't talk about this explicitly, but there is some sense that there are costs, not just the cost I already talked about spending hours collecting information that has to be billed to a firm, but there's also potential costs in terms of introducing the opportunity for satellite litigation around the waiver of privilege communications. Is there anything like that to sort of constrain or to affect the debate over disclosure in the jurisdictions that you're been asked to represent, all 26 of them or something?
28 now, I got. Sorry, it's confusing up and down, sorry. Not at the moment, I think it's changing, but at the moment, I think, given the fact that only very specific entities are allowed to bring kind of class actions, it's more like an ad to use a third-party funder. So we really have a legitimate claim because even an outsider is willing to give us money and to invest in us. So I'm aware of the VW cases, which is still going on in Europe. And I know, for example, and I just ask to make sure that I'm not telling any nonsense here, that the Austrian consumer organization who is using a third-party funder is telling the consumers represented, but also the courts and the public and also VW, we are using this third-party funder because our claims are legit and we have the money to go through with the claims. So, and it's not so much going in the waiving of the privilege.
So in your experience as an observer of the current landscape. You mentioned something, and I want to focus on this for a second. I don't think the chamber has really picked up this argument for disclosure much, but you said something about how it might be worth disclosing to the court. It might be worthwhile from a public policy point of view, because the court might want to ferret out whether or not the litigation is being funded by a competitor.
Yes.
Are there these sort of abuses of the third-party funding system in Europe to promote business ends?
To be honest, I think the wording of this article of the directive is the influence of the American Chamber of Commerce in Brussels, because I'm not aware of any abuse, but and that a competitor, maybe you know something else.
I've not really heard any talk of concerns that a competitor would be funding.
Yeah, no, so I think it's.
But you mentioned something
not
you said, like,
happening.
you think there's litigation sometimes it's in union litigation where it's being funded in the United States for pretextual purposes.
So, but that's a sort of ideological pretext more than competitor pretext, though, you know, and not to take the position. If I'm the representative for the chamber needs to call for help.
They also need you to lean closer to
I'm
the
sorry,
mic.
but I did speak with John Beisner recently, so I slept on a Holiday Inn Express last night. But they have started to talk about this. Well, you know, what if basically the Hulk Hogan, Peter Thiel model takes on and you know, Taiwan put so much on the table today, but I mean, so much of, you know, what we're going to have to get into, right, is if we're going to disclose to a court in the United States that governs trans substantive rules that govern disclosure and trans procedural cases, right, that run the gamut from one-on-one litigation to MDL to class actions to everything else. And we're looking for this one disclosure rule, which the GAO says that state and federal courts are going to provide data on. Then how would we ferret out if that's actually happening? So I'm not sure the chamber is completely off that, but again, I'm not, I don't purport to speak for the chamber, but they do bring up examples like, you know, what if you're a patent troll? What if, you know, you're trying to prop up a competitor litigation?
Okay, so thank you. So let's move on to Verity. Verity, so from your point of view, in terms of watching this happen as an attorney advising clients, how do you see funding disclosure as do you see it as a problem, or maybe do you see it as an opportunity even to sort of help promote the ends of your clients?
Okay, firstly, to say that I think in the UK, we obviously think about all of this stuff a lot less than you do, because the idea of a competitor funding just doesn't really get spoken
It's just not
about.
cricket.
It's just not cricket. But I think the answer to your question, it really depends on the level of disclosure that we're talking about. If we're talking about the fact the matter is funded, then I think that's good for all parties. That little bit of transparency, it means that the plaintiff or the claimant can show that they've got an independent backer that thinks that they've got a good claim. It's good for the defendant. They know they probably need to take it a little bit seriously because it's not going to just go away because there's a funder in the loop. So at the basic level, I think disclosure at that level could be good for the claimant. And I think at the next level where you're disclosing the name of the funder, that can be good for the plaintiff, beneficial, and an opportunity if they're with a reputable funder. It's obviously good from the court point of view because it helps you to identify, you know, base level conflicts. So if the judge is sitting on an investment committee, or if they're married to the CEO of the funder, for example. But it's starting to give the opponent quite a lot of information about potentially the merits, because of that, the reputation of the funder will play into that, about the cost of the funding itself. And at that point, they can start to think about what typical terms might be in the agreement and how they might start to cause a little bit of a conflict between the claimant and the funder. So it starts, once you've got the name of the funder, it's not really harming anyone, but it can start to cause a few problems. And to Di's point, if you're going all the way back to beyond the entity to the investors, then that starts to make it less appealing for investors to put their money in the first place. Where do you start?
Well, can you expand on why that is?
Because typically investors will have their fingers in lots of pies, and it might be that they are suing or that the case is against an opponent that they also have an interest with. It might unearth some tangential or potential conflicts that aren't really related to the case, but it might reputationally be slightly difficult.
But is that a intermediate problem that will be resolved over time once people get used to actually seriously considering the substance of such facially, concerning of conflicts? I mean, there's a difference between saying we have to look at this and then concluding that for that reason there is going to be an actual conflict requiring recusal, and saying we have to look at this and you know what, it's not a problem. And once you do that 100 times in a row, the 101st time, you don't even raise it anymore because you know what the court's going to say.
Maybe so, but it still makes it less appealing for an investor to get involved if their investment is going to be disclosed, I think. But I think as you move back to the next level of disclosing the agreement, that's really problematic for the funder and for the claimant. It's great for the defendant because they can start to use arguments that they can decide they're going to waste some time, rack up some costs, be really difficult, and they've got all of the evidence they need to be able to do that. They can start to drive a wedge between the funder and the claimant because they can have a really good guess at what sort of offer is going to cause some problems in the camp. So I think on balance, there's a balance to be had as to how much you disclose that is beneficial to both parties, and then the more you disclose, the more it just gives a really unfair tactical advantage to the defendant.
So I asked you this question earlier, and it sounded to me that your response suggested that it was sort of a pointless question, but I'm going to ask it again, which is in the UK or in the EU, where you have a automatic loser pays system, where you have basically adverse costs being charged against the loser. Does this add an additional sort of element into the costs and benefits of disclosure for the plaintiff?
I hope I was more polite than to suggest your question was pointless.
No, you did. I mean, that's
But yeah, I mean, it potentially gives more reason for disclosure, but actually the way that it certainly works in the UK is that there's still no obligation to disclose, even though there's a loser pays principle, and so typically it's not, unless the court orders it, which will usually happen in one of two situations: a security cost application, or you're trying to get certification for a class action. Because of the loser pays principle, of course, most funders would be insisting on an adverse cost insurance policy. So at that point, the funding agreement itself and the disclosure of that is almost put to one side, right? Because what they're really interested in is the adverse cost policy. Now, you might choose to, or it might be, you might need to disclose it, but it will be heavily redacted. So yes, there's an impact,
but it's not much.
But it's not really much.
Especially because of after the event insurance.
Yes.
Yeah. Okay. All right. Yeah. So that's very helpful. And then let's move on now to Maria. So we've sort of thrown at you a lot of different questions. Okay. And you can pick and choose what you want, or I could ask you specific questions, but I know that you have a lot that you wanted to jump in on. So.
Well, sure. Why don't you start? I mean,
Well, let's talk about the cost question. Okay. Yeah. You've studied this, and you know what I think about the cost argument in terms of the kind of irony, right? Mm-hmm. Yeah.
Well, something Verity was saying that strikes me as particularly salient, again, against the U.S. backdrop and the U.S. litigation system, which, just acquainting some of you whom I don't know, I'm a civil procedure complex litigation scholar, so I'm coming at this kind of from that perspective. And if you look at sort of the history of disclosure and the history of litigation sharing, so much of what we've sought to protect versus disclose is things that are core to the adversarial system, right? And I think what is so difficult about litigation funding and disclosure, putting aside all the subcategories and complexities that don't seem to lend themselves easily to a rule or to a regulation, is that to the extent the adversary finds out some amount of information, more information, as Verity said, it can be a slippery slope, and where's the line? Would they be using it to ferret out the things I've heard judges care about, which is, either competitor litigation or bad deals, frankly, for plaintiffs who may not have as much agency? The chamber talks about bad settlements, but unless you're in a representative capacity, I'm not sure judges typically don't care about bad deals. But the more adversaries know, it's not just an issue of litigation advantage, though it is, it's an issue of being able to structure and impose costs on the other side via satellite litigation, via litigation about the funder, which is somewhat of a unique tax on a funded entity. And so is this something, to your definitional point, we need to be thinking about, at least in certain contexts, as being analogous to or an extension of work product, an extension of adversarial preparation? And then what does that tell us about how much the funder's controlling the litigation, right? Because you're thinking through things. But I feel like the GAO report and other regulatory proposals, such as amendments to Rule 26 so far, strike with such a broad brush that even if we could control for the adversarial advantage, which I'm not sure we could, what's to stop this just from becoming a pro forma disclosure every time that just generates tons of paperwork, and no one, including the judge, really knows what to do with it?
So let me just take over the ghost of John Beisner.
Okay.
The ghost will
Hello, John.
transport from you to me now.
Okay.
And say, well, that's kind of rich. For 20 years, the plaintiff's bar has been always answering the objection of burdensome disclosure by saying that's what we have judges for.
Mhm.
We don't want and don't need a hard and fast or per se rule. We should just simply let the system process these reasonable requests. And even if one of every 10,000 requests gets accepted, it's worth it, because, to sort of coin a phrase, it's better for a relevant piece of evidence to enter into a court than for 9,999 to be rejected unfairly or something, right? I mean, the idea that we can handle this through the regular litigation. The cost argument has often been rejected by the plaintiff side
Mhm.
as a pretext for getting rid of access to information. And now all of a sudden, says John, you're making the cost argument be sort of an argument for a per se rule.
Well, I can at least say that I'm on record saying that there's nothing if not strategic hypocrisy in litigation, and that's what you'd expect. It may not be the most intellectually consistent position, at least at a high level, but at some point, if you break it down, it's not just a cost argument. And so if you're trying to create coherence, which I'm not sure that's where we're going, but it's not just a cost argument. So if you're producing, as you said, 999,000 pieces of evidence and only one's relevant, let the court sort it out. One, would that evidence give a particular strategic advantage to adversaries against a particular subgroup of people, namely funded entities that would not inure to non-funded entities? And second, and I don't mean it strikes me as interesting, having talked about transparency in a related context, namely claim uptake and settlement for aggregate litigation and MDL, and how we barely have data in our courts about claims filed. We barely have the resources and capacity to have data about, parallel litigation and MDL, that we would reasonably expect courts to sift through all but the most obvious problems, right? A conflict, right? That the judge is married to the funder. I mean, okay, let's catch that. But other than the most glaringly obvious problems, Hulk Hogan and Peter Thiel, you're talking about a disclosure that risks being not just a cost, but an adversarial advantage to a judge that is supposed to do what with it? And other than police for the most obvious conflicts. And I've talked about this to some degree with John, which is, don't, at some level, what you're talking about, if you're talking about tendentious litigation and ginning up litigation, that's one thing. But if you're talking about protecting the plaintiffs, if you're talking about protecting the industry, or you're talking about protecting even the sanctity of the judicial system, you're talking about forensic auditing that judges don't really have the capacity or even the knowledge to do. And so I think asking, what are we disclosing for, when, and what types of cases? And, you know, to your point about, oh, this doesn't match up with this in terms of requesting evidence. Well, why are defendants saying they don't want to have this produced? Well, what I hear is, well, they're ginning up litigation. But that's only one concern that judges would have. And it's not the concern that they articulate the most, in my experience.
So that way, you had sort of introduced it among the group, at least, this concept of key terms as a way of perhaps, I think you thought it would be kind of a compromise or an olive branch.
Or more like an efficiency. So if we're dealing with how do we define all these things, what do we really care about? We have this patchwork of federal, state, local, international rules, common law. There's kind of a soft movement in the UK for model documentation, which I think is spearheaded by Brown Rudnick and Lionfish, or wherever they end up. And I haven't followed that closely, just because I think in the US, which is where I work, that concept's never going to get off the ground. The docs are way too heavily negotiated. They're way too bespoke. You often start with a certain type of template, but after that, things can go off the rails, and deals can be very different. So model documentation, I think, is a challenge, but that doesn't prevent us from having some form of document that, for instance, the trade association could issue, like the ISDA master agreement, which is just key terms, things that aren't controversial, that we're in a situation where there's disclosure, such as in New Jersey, or in Connolly's courtroom, or in, Central District of California. If it has to be disclosed, the form that the local rule is going to require is going to vary. And there's going to be different things about, well, is this funding? Is this not? And basically the idea is take the non-controversial concepts that everyone on the funding side says, we're not these bad actors, trust us. The other side says, well, we can't trust you because we've never seen your agreements. Well, we can show the agreement. We can have a one-page agreement that says these are the key terms related to the policy issues underlying disclosure, such as, basically mirroring what Judge Polster put in his, what he called the 3PCL dual affidavits, basically non-controversial things. First it would say, this is the, part of the litigation funding agreement. To the extent there's any conflict between the terms of this and the balance of the agreement, this controls. And this says the non-controversial things, such as there is no control. There's no interference with the attorney-client relationship, things that we say and know are true that will actually put it out there and alleviate the court from having to mediate a dispute involving this, because it will be in front of their eyes. It will be produced on the condition that there's no more discovery. Let's just shut up and move on.
So,
Yeah. And I have a question about that, and correct me if I'm building on something that presumes something that you're not saying. So one thought I have had is there's so much push for discovery in this case. And I think what you're getting at, and what I've thought of, is what if the disclosures were more general and the regulatory framework was more general, that funders have to be in certain positions vis-a-vis cases, period. They have to be in certain, distance from the attorney-client relationship, period, and that they have sort of regular compliance disclosures, but that we start to identify what is the intent behind getting this disclosure that the judiciary and our regulatory bodies are behind, as opposed to case by case. Well, we need to know this for this. Is that kind of what you're getting at? Because it's something I think might make and be more workable, just to regulate industry abstractly and with guardrails rather than case by case adversarialism.
Well, I think we already have that. The rules of professional conduct effectively do that. And if you try and start saying a funder can only do this or that, it's going to get too complicated. Because what if a funder is an equity investor in a company? What if part of what it negotiates for is a board seat? You can't stop someone from participating economically like they can legally otherwise, just because it involves funding of a litigation. There's no basis. Nothing's been articulated for that, especially when you have protections that are already built in.
Well, but I mean, that's potentially the point, is that if we have protections already built in and maybe we agree that they should stay, why wouldn't it potentially be an idea to disclose along those lines, as opposed to, this party's being funded, this is the contract, these are our general approaches.
Yeah, I mean, so just to sort of maybe pull back for a second from Daiwei's suggestion. The one way of responding to is saying that there is nothing or objectionable about it, but it's a little bit like tofu. It just, there's not much to it, because I mean, this clearly isn't going to give either the court or the adverse party what they claim they really they need in the rare but worrisome case where they're going to have to do something. So, for example, being told that there is an agreement, but we don't tell you with whom, and we don't give you any details about it, and it conforms to the law of our jurisdiction, seems like saying that there might not have been an agreement, but there is an agreement, and we're following the law. It doesn't tell the other side, for example, what they need to know if they believe that there could be a conflict resulting in recusal. It doesn't tell them, for example, if they believe that there is a sum of money out there that's going to change how they're going to approach settlement negotiations. I mean, whether or not this is information that, well, the first is information that should be provided. The second may not be information that should be provided, but it's certainly, your proposal doesn't even address the real motivation behind, I think, funding disclosure requests.
Well, it depends who's requesting the disclosure. Like, let's be clear, the judges care about different things than the adversaries. And part of the problem with the disclosure debate is you've got a mishmash of different settings of litigation where disclosure is sought for different reasons. For instance, in the mass tort context, they may seek disclosure for efficiency. We want to make sure the right people are in the room because maybe the general counsel of the defendant is getting approached by lenders directly and finds it obnoxious that the law firm hasn't disclosed that or is otherwise making excuses but not including them in a contentious commercial private dispute between two parties. It's very different, and there's the strategic advantage question. So if you're addressing it from what the court might care about, what I'm proposing is basically what's already being required, but it actually gives an agreement. So there's not a dispute of, no one can keep saying, well, we've never seen one of your agreements. Maybe you haven't seen the rest of my agreement. There's no legitimate basis for you to see the rest of it except for strategic advantage. And it's, to be clear, it's very dangerous. And I think people who haven't sat in the seat, if you haven't gotten a subpoena as a funder in a case, you don't understand the discrepancy behind what different constituencies are seeking. Like, we got a subpoena recently in a case that we're not even funding. Once a deposition, there's 50 document requests, and that's not atypical. It was disclosed that we're funding a case recently, and the defendant threatened to sue us because we were, aiding and abetting a post summary judgment, but somehow frivolous litigation. So we're not scratching the illegitimate itch, but we're scratching the only presumably legitimate ones, and then we can just move on.
But to your point, why do judges want it? Why do litigants want it? And I think the adversarial, normally I think the adversarial request is bad for all the reasons we articulated, but a judge is in a very different capacity in an aggregate litigation in terms of why they want the funding disclosed. It's almost a fiduciary duty toward the plaintiffs versus, as you said, the complex commercial litigation. And so part of what is driving at in terms of disclosure beyond sort of rules of ethics, or why else might judges want them? Not why the adversaries would want them, but why else might judges want them? Are they in some sort of fiduciary or quasi-fiduciary capacity? Are they managing a steering committee? Are they managing, post-settlement loans, right? We saw in Henry NFL that there was potentially concern about the relationship between the funders and the post-settlement loans. So articulating the types of, as you put it, legitimate reasons we'd want disclosure might give us a framework for what those disclosures look like in certain cases, but to the industry more generally, so you avoid the adversarial dynamics.
But that's the problem. So take mass tort. The funding there cannot really be used for strategic advantage in the same way, right? Like in the mass tort context, you have individuals who are getting advances, right? Who cares about that? If that's disclosed, not a big deal. And you have law firms receiving financing, either recourse or non-recourse. And that's a big issue that needs further discussion, is why there should be a distinction.
So can we
there
just
for
stop
not-
for there for a second? So when
Yeah.
you say in the mass tort context, the MDL context, there are individuals receiving funding, and what's the big deal? Who cares about that? Actually, there is some controversy about that. And I just want to understand what you're saying. Are you taking the position that, from your perspective, it would be a good thing if there was regular, transparent, automatic disclosure of whether or not lead generators were, for example, taking an interest in the outcome of cases, or whether or not doctors were receiving funding from funders that were then contracting with people who have a claim for personal injury suits. That should be what we have now is the New York Times looking into it. Instead, we should
Yeah.
have some kind of structure by which this is automatically disclosed to the court or to the press or to the adverse party. And where's the harm in that?
So what I mean is I approach this all from a prejudice perspective. So this is my bias from where I sit is on the commercial side of things. Disclosure is a huge nuisance. I think it's annoying that we can't talk about what we do all day with one another. For instance, I think it's annoying that our job has to be so much on the phone just because of the specter that something might have to be produced one day. In the mass tort litigation, if it's mainly attorneys receiving financing or the other things you're describing are really consumer protection concerns, what I'm saying is the folks who are really fighting about disclosure most of the time is in the commercial context where there's actual substantive communications between a funder and its counterparty or terms in an agreement, which if disclosed could prejudice the case. That's not present in the same dynamic where it's, mass tort firms with a ton of debt and we want disclosure for an altogether different purpose. So, but that's part of the issue is there's disclosure fights happening in the aggregate litigation side, trying as a backdoor really to create law, which can then be used in the commercial context where there's the potential
Susanna
for
in for a second,
prejudice.
because one thing Susanna mentioned earlier is that actually where there could be some traction on disclosure in Europe is the question of disclosing to beneficiaries of class litigation who don't even know that they are the beneficiaries of third-party funding, right?
Right. Under the amendment for the new directive, which, and this might be interesting for the people here in the US. So the directive had to be transposed in the national laws by December 25th of 2022, but most member states didn't care. So they violated the obligation under the European Union law. So just to show you that how much reluctance there's against aggregated litigation at all, not just third-party funding. But one of the amendments to the directive, which has not yet been transposed into most member states, is that disclosure should be made towards also the parties represented by the qualified entities. And I think that's not a bad thing. It's good to know and might even trigger more opt-in because basically everything is opt-in in Europe. If consumers know that there's enough money behind the claim. But the amendment also suggests that the defendants have to ask for more details about the agreement. And I think that's, for the reasons we already heard, not a good idea. But I think there would not be any harm in just to tell upfront, okay, we are using third-party funding, that's our funder, and that should be enough for everybody involved, right?
Can I ask her a question really quick? So in these jurisdictions, I mean, it's different. A lot of the times the lawyers cannot work on contingency. So you need
Yeah.
third-party funding
Yeah,
for a class because
definitely.
the class isn't funding it. Do you think that if lawyers were allowed to do the cases on contingency and fund it themselves, that their capital sources should also be disclosed?
it's a tricky question, but I guess because it's a theoretical one, because the system will not change anytime soon in Europe. We don't really need an answer to that now. And I think the problem is also because even under the directive, only those qualified entities are allowed to bring, so mostly consumer organizations which do not have any money. So if there's no third-party funding, there will not be any cases. I mean, it's different in antitrust law and in the UK, but for most jurisdictions within the European Union, I think they depend really on third-party funding.
I just think that logistically, it's not that feasible for many multi-claimant cases, whether they're class action or just multi-claimant, to run without third-party funding or a law firm contingency fee, because just the process of invoicing and collecting money from multiple claimants just isn't realistic. So third-party funding has to be an answer there.
Yeah. So I want to make it clear, analytically, we've been talking entirely now about client-directed funding. Were we talking about lawyer-directed funding, where law firms are taking capital from a funder. Then there's a separate issue about disclosure, which was addressed by the working group of the New York City Bar, which is whether or not the law firm should tell the client that they're receiving third-party funding for that specific case or in general for the firm. I want to keep that off to one side only because we only have 15 minutes left, and it's a separate and important disclosure question, but I think it's separate enough from the one we've started with the client. And I want to go back to Daiwei's proposal and say, what other kind of proposals could we think of? So like, for example, like, I mean, as you know, I have this idea that it's important in thinking about Judge Connolly and thinking about New Jersey and thinking about how 7.1.1 has been tweaked. I mean, one thing that I have been thinking about is, well, why is it, and do federal judges really want to be the recipient of all this information? I think, you know, some federal judges might say, I'm not the first line of defense on this. And for example, it might be the case that the best way of handling this is to have a rule that has automatic disclosure to the adverse party, right? You tell the adverse party about this, but the adverse party then is subject to very limited restrictions about what they can do with this information. So for example, a protective order is attached to this transmission information to the adverse party. So the adverse party, for example, can't give it to the New York Times or can't give it to a third party because they're not allowed to. Now here you put the burden on the adverse party to just do the heavy lifting as to whether or not they think there's a issue to be raised to the court. This happens all the time, but I think the court would prefer this than rather it being deluged by tens of thousands or thousands of bits of information that they generally are useless. 99.9% of them is irrelevant. And I think the truth is that the adverse party is the party who wants to hear this, but the truth also is the adverse party shouldn't be able to use this for prejudicial purposes. They shouldn't be allowed to, for example, presume that there's been any waiver of work product or attorney-client privilege, and they shouldn't be able to breach confidentiality by allowing any other third party to use the information they've received. That would be one solution. And finally, this thing would be all they get to know is what New Jersey says they should know. There is funding, the name of the funder, and that's it. Not the amount and nothing about the internal documents.
I think, so I'm interested in what others have to say. I just want to make a broader point, which is that disclosure is like a battle in a war, right? So like disclosure is where we're fighting about all these things and all the negative things are coming out, like the Peter Thiel example, for example. One case, by the way, he went on to seed a funder that I at least don't think has ever been accused of funding cases for personal animus along with him. They fund a lot of cases that, and people have opinions on them we don't need to get into, but that's Peter Thiel also. But in any event, and this goes to the reputational point that Verity was making. Once there's disclosure, don't think it's going to stop there. Newsflash, funders lose cases. No one likes to talk about it, but it happens. And when we lose cases, there will be a record perhaps that there was funding. And it's like, you'll see the defense bar saying, well, it is frivolous litigation. Look, they lost these 6. Meanwhile, we've won a lot too, and a lot have settled, and there's reasons we may or may not be able to talk about them, but it'll keep coming up. So the funding is a problem, not because of disclosure and champerty and fee splitting. Funding is a problem because of the general concept of putting more money into litigation where it's historically been tilted. So just a reminder on that and why we'll never really get to a compromise. But if we're able to have smart people craft rules, I'm all for it and curious what you have to say.
Yeah, I've, to your point about mishing and mashing, I think you said, I mean, there's so much argumentation coming from, you know, the chamber and the anti-litigation funding wing that transposes some fairly aggregate litigation specific concerns about consumer protection and client protection into contexts that don't really shift trans-procedurally. And then the general argument, and this, you're seeing this come up, and we're seeing this come up in the context of individualized claiming that is nonetheless on an aggregate level, whether it's an arbitration or it's in litigation. And that is that we need to have disclosure if firms are even using funding to generate clients, because that is wasteful litigation per se. And so I'm not a huge fan of slippery slope points, but I see the funding agreement as, again, more close to a work product adversarial litigation preparation that once you give it to an adversary, not the judge, not maybe a third party or agency that monitors generally, but when you give it to the adversary in a particular case, absent specific reasons like an aggregate fiduciary supervision capacity, when you say do federal judges want to see it, they absolutely do an MDL, right? Judge Polster, all of them want to see it. If you superimpose those on other sorts of cases, it becomes, I think, a weapon in the procedural arsenal that, again, inures a specific tax to specific litigants who are arguably already at a disadvantage. And so disclosure to whom, for what intent, and being very careful about the reasons we need it in different cases, I think is going to be critical for sensible rules and regulation.
Just to touch on what you were saying about litigation or funding being used as a marketing tool to get more cases. It's interesting that you see it as that point as increasing litigation in that way, whereas I see it more as increasing access to justice, because I know that funders would like corporates that have no cash flow need to use funding, but typically most litigation funding is used by a claimant or a plaintiff that doesn't have the funds themselves and therefore can't access justice without it. Yes, some corporates will transfer, the risk to a funder and transfer it off the balance sheet to a funder, but by and large, litigation funding must be available for those claimants that need access to justice. So I just thought it was interesting that your main point was about it increasing unnecessary litigation rather than litigation that needs to be brought and there's no other way of bringing it.
Okay, so do you have any other questions you want to ask each other, or otherwise I can open this up for questions from the audience?
Can I
Yeah.
just second this? I think really also within the European Union, it's about access to justice. And I think it's interesting that the discussion before the directive was very much against aggregated litigation at all. And now that the directive was passed, may it be ever transposed in all member states, the discussion shifted to third-party funding. So if you can prohibit aggregated litigation at all, let's try to get the funding away so that there's no more access to justice. So I think it's really about access to justice.
Well, that actually does bring to a question I want to ask all of you, but Maria, we talked about the timing of disclosure, and I mentioned, it seems to me that the one interesting question about timing would be, maybe we should have disclosure of funding at the end of litigation in the context of aggregate litigation, if there is an obligation of the court to decide about fees, right? And then is that a time where we should have some structured mechanism, some rule that actually describes what should be disclosed? Right now, there's nothing clear about, and even it's not clear whether it's even relevant.
Yeah, I mean, my own developing view is that there really is a set of distinctions between aggregate and even distinctions within aggregate litigation and non-aggregate litigation. And one could imagine a situation in which it is relevant to fees in terms of risk taken on, public value, all the balancing factors, right, that we potentially could put into an analysis. One could make an argument that under the aggregate settlement rule, like, was this disclosed to the client, and were the dynamics of pursuing litigation and the cost of that disclosed to the client such that assent or consent to settlement under the aggregate settlement rule was truly informed. Again, none of that really needs to involve the adversary unless you have a concern about the adversary and the counsel and potentially even the funder collaborating in contradistinction to the client. Another temporal placement that again is probably unique to aggregate litigation is in a structured settlement, and with loans coming out after a structured settlement. And that does become something federal judges don't want to do, and B, arguably the sorts of thing that would be so resource intensive and expertise intensive that would be difficult. But if you're talking about providing data about claim uptake and loan procurement and who's funding the structured settlement, then you do implicate those sort of client representation and conflicts potentially between attorneys. But those are very specific. And I think it will be critical going forward as you know, everyone's considering this, to make those distinctions and not just paint with such a broad brush.
But isn't there, don't you have to go back farther and say if certain types of things, if an attorney is receiving some sort of financing and that must be disclosed to the client, should the rules of professional conduct require disclosure of any lawyer's creditor situation, what their debt load looks like at any given time? Because we've got this recourse, non-recourse problem, which the city bar, it was
Yeah.
problematic, but I don't, I don't know where you draw the line there. And in the
Not where the
aggregate.
city bar did.
One of them was right.
But in the aggregate litigation context, when you talk about kind of oversight, talk about a class action, to the extent a funder is eating from an attorney's fee award, and that fee award is determined irrespective of the financing, I'm not sure where the disclosure comes in there.
Well, I think it comes, and you can draw a line, right? I haven't articulated it in chapter and verse, but you can draw a line between how the firm is conducting itself generally, what its portfolio of cases is, what are its claiming models, and how is it generating the revenue to fund its different cases as a firm matter, and what funding specifically was acquired to advance your case, and where you are strategically in the proceed or stop sort of run fast and long options perspective. That seems like a reasonable limit.
But then, so back to where we started, what is funding? So I'll give an example. There's a beauty contest going on in a certain jurisdiction where there's contested lead slate. And various firms have come forward and said, we don't receive funding. And that's supposed to say, because we have the wherewithal to bring this case forward. So there's a firm that almost everyone in this room, I'm sure, has heard of, who says in their application, we don't rely on third-party funding. Now, they do publicly have securitized debt,
Yeah.
which you can buy. So what's the difference? Why do we care? What if there was a default there? How does that affect?
And I
all
always
these
wonder
concerns?
why judges aren't simply asking that firm, well, wait a second, doesn't that make you inefficient? If you actually got funding, you could actually do all this work for less, and you could actually give more to the class.
Or maybe you'd have less of a conflict, but
Yeah, okay.
class action funding is, I want to go back really quickly to something you said about work product. And I'm gonna,
I think we do
yeah.
need to, I just want to make sure that if there are any questions, because otherwise.
Sure.
Yeah, are there, and otherwise we get back to Daiwei, but yes, Aviva, Will.
We're talking about latest and that legislation needs to be about. From actual experience, not what you hear or what you read in academics, that increasingly those that are dues paying members of the paper, and I often think they ought to be careful what they wish for, are taking funding either off the defense side of the risk or on the plaintiff side, or a combination of both. So I question, whether the intention
here for any of this potential regulation is to be two-sided, because I think that would mute this issue very quickly. We keep confidentiality both of our plaintiff side funding, our defense side funding, and everything in between, because we value the work product and protections that litigation affords those clients. I just query how much the chambers would be happy if this was in fact a two-sided disclosure.
As a point of information, Aviva, do you think that 7.11 or Connolly's order actually applies to any of the cases you just described? I mean, I'm not putting you in a spot. I'm just
Yeah,
wondering.
it's a good question. I probably have to defer
Andrew
to
might
Andrew
know.
on that one, because I don't spend a whole lot of time with Judge Connolly's order.
Disclosures in Delaware on the defense side of funding, none of which are what I think any of us consider litigation funding, insurance policies.
Yeah.
Other sorts of indemnities, but nothing.
Yeah, look, I think Burford would be happy to display in the New York Times on the front page who our clients were. We could dispense with every dollar that we spend on marketing if people knew who our clients were. Because if that was the end of it, if funding were corporate finance for law, which I believe that it is, and it was of no moment, it is the frolic and detour and the cost of it that prevents us and our clients from seeking to do that.
Okay, there was another question. I'm just gonna go across the room, so yeah.
curious what the feedback is around the defense side. Or the fact of, sort of it being two-sided disclosure, in fact, there should be disclosure.
I mean, I think at some level articulating the same principled intent for why we just should disclose. If there is an adversarial protection element, that would presumably go both ways. And then to the extent there's a concern about, whose ox is going to be gored if there's competitor litigation or if there's abuse of the system for ideological gain, that might happen more often on one side or another. But I think we have to be open to the fact that this would cut both ways. And it is being funded both ways. I don't think you can have a goose and gander split necessarily, but you have to ask the nuanced questions.
But you're flipping the insurance argument, right? Which is what the defense bar always says. The insurance argument's disingenuous for, I don't know, 8 or 9 reasons, probably mainly. But the main one, and this is actually my question for Maria, and we can discuss it later because we're out of time, is, should we just codify a privilege? Because on one of the most disingenuous things about the insurance argument is that there is a privilege between once the duty to defend is assumed. So if we just codified that in the rules of civil procedure, would cut off the ability to get anything prejudicial, and then we could maybe move on.
Yeah.
That's your thing, move on.
Yeah, no, I mean, and it took the courts about 20 years to create that as a matter of interpretation of the rules of evidence, but there is no codification of it. Yeah,
We could codify that.
we could codify it. Yeah, I could do it in a minute. Yeah. Okay, yeah.
Yeah, this may be a timely question, but I'm curious how this discussion ends, right? Is there anybody actually positioned to set, a rule that would be used as a model by everyone else, and bring this to a close? Or is this going to be the sort of thing like tort reform that bubbles up every decade or so when, a particular group of defendants decide it's worth talking about?
Yeah, I think there are proposals out there. I mean, people can think of, there aren't, as I mentioned, I think you could amend Rule 26 in a way that would actually serve the purposes of what we've been talking about, maybe not with the subtlety and the granular degree of, finding the purpose behind the disclosure. But, rule writing is, of course, under and over determinative, but I think you could do it. One thing that I just said is, well, why don't we just admit that this isn't really about disclosure, this is about waiver of privilege. If we simply just grafted the common law interpretation of privilege extended to insurance providers, right, which is purely a matter of judicial creation, onto the thing that we call a third-party funder, but then we have the problem defining a third-party funder. But we could do that, then that would actually be a detour around this entire discussion, because then you discover, as Aviva pointed out, that then all of a sudden, a lot of the people are asking for disclosure are no longer interested in it. That's my, are we out of time? Are we time for one more question? Okay, yeah.
Thanks, Tony. I'm wondering if the panel could be more precise about what they mean with the concern about strategic advantage if the defendant has access to the funding agreement, because my understanding as to why a defendant might want the agreement is because the defendant and the lawyers, they want to plan and make decisions about how much to invest in the litigation. And that's the same reason why plaintiffs want access to the liability insurance agreements. They want to know how much should they invest in this case. Now, I gather you could say, well, the defendants want this for more than just investment decisions. They want to create some kind of conflict between the client and the funder. They want to know where they can make their settlement offer to exploit conflict of interest. But that's the exact same thing that plaintiffs do with the liability insurance agreements. Because of the duty to settle, the plaintiff can make quite a conflict arise between the insurer and the client. And so I'm just unclear why the strategic advantage the defendant would get would be any different than the strategic advantage the plaintiff gets when they have access to the liability insurance limitations.
So the insurance, another problem with the insurance is that information often isn't useful because of how limited it is. But I'll ask you a question. Can I have your defense budget? And can I also have control like an insurer has? If you give me your budget and you let me control the case, I'll give you my funding agreement. If they know how much money there is and there's an impecunious plaintiff, they'll know when the funding runs out. Funding is not unlimited. It's not, I think a misconception is, oh, so-and-so is funding a case. That doesn't mean we're paying for all of it. It's a complicated, heavily negotiated risk allocation with often limitations based on phase in a case, things that might happen, certain reps and warranties that are very specific to a counterparty. And also return structures that could be manipulated. If you knew, for instance, when a multiple jumped, or if something's going to trial, there's going to be an immediate increase because of the change in the risk profile. All that could be manipulated strategically, knowing what a liability policy says and nothing more when the insurers have a privilege that we don't and also have control isn't really apples to apples. That's the response.
We have one more question, if we have time, I don't know.
Did you have something to say?
Yeah, I was just maybe, if you have time, to the question, I think, in Europe, and I'm now mostly thinking about Germany because that's the jurisdiction I'm most familiar with. Outside the qualified entities consumer cases where law firms, American-based law firms, have initiated kind of aggregated litigation against companies in antitrust law, but also VW cases. The defendant, differently from the consumer organization cases, tried to stop the claim by saying third-party funding at all is unethical. So I think if they have access to the agreement, that would just help them to prolong the litigation. And again, we just heard that funding is not unlimited. If you can just continuously ask for documents and have more questions and more questions, it's just a way to prolong litigation, because the German Supreme Court only ruled last year that third-party funding is allowed in this antitrust law cases. And
So, and,
Yeah.
and in the UK on, in those matters where the agreement is disclosed, even if it's redacted, then what you do tend to see is you tend to see quite a lot of extra time, extra resource going into just running the money out, running the budget out, or just really wearing down the claimant. In my experience, it is used sort of much more readily by a defendant than the insurance policy is used by a claimant.
To Aviva's point, it would depend on, right, the structure of the defendant, but I guess hypothetically, the same sort of thing could be used against defendant. To Di's point about it, it's sort of their budget, right? It's sort of, and if you have these options, that you're exercising these options every stage of the litigation, then it could go right the other way, hypothetically.
Just really quick, one other thing is that I can only speak for my business, but there is rarely insurance coverage on the other side of the cases that we fund for obvious reasons.
And from my point of view,
The obvious reason is that there's not insurance coverage for many of the types of claims that commercial funders often
Because
bring.
they're commercial.
Because they're commercial in nature,
Yeah.
antitrust coverage is rare, patent,
That's right.
there isn't really a
It's
market.
not personal injury, it's not liability for
Exactly.
damage, property damage, it's, yeah.
And I spend, I mean, I work at predominantly a defense firm, so I actually spend quite a lot of my time advising the defendant clients just how they can make use of that information. So it does happen, the defendants will use the funding agreement to drive a wedge between claimants or to spend more time and money than the claimant might have anticipated originally.
So the arguments that have been made on why a generalized disclosure requirement is unfair has always been made on the assumption that it's always disadvantages in terms of the interests of the funder. And I agree that most of the time it will be against the interests of the funder. However, isn't it also unfair in the sense that disclosing the funding itself also gives the funder and the funded party an advantage, and it hints that the funded party has a very strong claim because this is an investment and someone is putting money who's a non-party to your claim. So that's also, in my opinion, makes it unfair. And I wondered what your opinions on this are.
I think there is a benefit to the plaintiff to saying they've got funding for exactly that point, but that's where we're saying a line should be drawn as to how much other information should be given, because there comes a point where that where it becomes too much of an advantage to the defendant and it can stifle the claim, it can stifle access to justice. So agree, it can be beneficial, but on balance, too much disclosure is tactically unfair.
And I think it depends on how whether and to what extent you think the quote market for claims is working and what it's working towards. I mean, is it incentivized or structured such that merit just means you can squeeze money out of the defendant and therefore the incentives to fund are not aligned with potentially meritorious claims? Or is it sort of the other side that says, look, we're not dumb. We're not going to invest in, bogus claims. The truth is probably somewhere in the middle. And I think the extreme argument that sort of comes from the anti-litigation funding side, at least from a one-sided perspective, is that, the incentives in the market is not efficient vis-a-vis the merit. It's sufficient vis-a-vis shakedowns. So I think
Yeah,
it depends on how we define the market function.
I think we have to stop. Is that correct? Yes, I saw, okay, we could keep going. But thank you very much to the panel. These are great comments.